Good evening and welcome to the Board of Commissioners regular meeting. Today is Wednesday, December 10th, 2025. It is 6 p.m. City Attorney, would you lead us in the invocation and Pledge of Allegiance, please?
Yes, our Heavenly Father, as citizens of the city of Madeira Beach meet together to address our local concerns and opportunities, we give thanks to you for the bounty that we enjoy in all aspects of our community life here. We ask for inspiration to strive for excellence in our endeavors to serve the public, and grant us peace in our world and harmony between all people to greater glory. This we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
City Clerk, would you call the roll, please?
Mayor Brooks. Vice Mayor Kerr.
Here.
Commissioner Taglerini.
Here.
Commissioner McGeehan.
Here.
Commissioner Gabayi.
Here.
All are present.
Next is the approval of the agenda. Do we have an approval?
I'd like to make a motion to approve the agenda as written.
Do we have a second?
Second.
City Clerk, would you call the roll, please?
Vice Mayor Kerr.
Yes.
Commissioner Taglerini.
Yes.
Commissioner McGeehan.
Yes.
Commissioner Gabayi.
Yes.
Mayor Brooks.
Yes.
The motion carried 5-0.
We have no proclamations or presentations. Next on the agenda is public comment. Public participation is encouraged. If you are addressing the commission, step to the podium and state your name and address for the record and the organization or group you represent. Please limit your comments to 5 minutes and do not include any topic on the agenda. Public comment on agenda items will be allowed when they come up. If you would like someone at the city to follow up on a comment or question made at the meeting, you may fill out a comment card with your contact information and give it to the city manager. Comment cards are available at the back table in the commission chambers. Completing a comment card is not mandatory. For any quasi-judicial public hearings that might be on the agenda, an affected person may become a party to a quasi-judicial proceeding and can be entitled to present evidence at the hearing, including the sworn testimony of witnesses and relevant exhibits and other documentary evidence, and to cross-examine all witnesses by filing a notice of intent to be a party with the Community Development Director not less than 5 days prior to the hearing. Do we have any public comment? Please.
Good evening, Commissioners and Mayor. Helen Price, 13300 3rd Street East in Madeira Beach, and I'm here representing the Board of Trustees for the Gulf Beaches Library. Just thought I'd give you my pop-up library report, since I sometimes send you emails and sometimes I just want to come down and see you. So basically, library's doing good, in really good shape. If you've gone to see it, you'll see the inside of it is totally redone after the storm. And we are having our annual fundraiser on February 26th, just to let y'all know. We're having a couple of meetings about that, so I don't know the exact format, but the chamber will be involved, and it'll be similar to the last one, I believe. I also want to remind everybody that there's a notary at the library, 2 of them, and it's only $5. I don't know if you've gone to your bank recently and got something notarized, but they're charging like $15, $20. But you can always go to the library and get it done without making an appointment or standing in line. Don't know if everybody's aware that you can check out readers and audiobooks from the library. We have museum passes there from many of the major museums. You can check them out. You get them for free if you have a card. For 2 people and 2 children, good for 1 week. But you have to go down and actually physically check it out. We also have a large archive of city documents, really all up and down the beach. Really interesting, cool documents that are kind of kept in the back. We're trying to show them off and rotate them out front, but if you go in there, you'll see some really, really neat older pictures of the library and things around it. Also, don't forget that the AARP does the taxes for anybody. You don't have to be a senior citizen or a member of AARP. Just call, make an appointment, and they'll go down and do your taxes for you. So really, that's it. Wanted to let you know we're having the fundraiser and that you're all invited. Everyone behind me is too, and you'll be hearing about it later.
Thank you.
Any questions?
Sounds great. Thank you.
Sounds great.
Can I ask a question,
Yeah.
Mayor? Just regarding the fundraising brick project, where are we with that? What's the progress? I know we got sideswiped.
Right. I believe they're either installed now or they're about to get installed, actually in the front of the library. It didn't work out putting them back as like thin pavers on top of the patio. Nobody goes out to the patio. So, and then when they came in, first wave came in and they were like 2.5 inches thick. Another wave came in, they were 2 inches thick, things like that. So we've decided to embed them in the ground right by the front doors where we have white rock.
Great.
So I'm not sure if they're there, but they're coming up.
Thank you.
And you could always get those year round. You just, the $100 though was only good for that 8 months that we had the project, so. Okay, and then there was something I remembered at the end, but, oh well, that's it. Any questions, email me or anything you'd like. Our library is here for everybody and it's a really great place.
Thank you. Do we have any additional public comment? Next on the agenda is approval of the minutes. If the commission has had the opportunity to review the minutes, there's no changes. Do we have a motion?
I'll make a motion to approve the minutes as written.
Do we have a second?
Second.
City Clerk, would you call the roll, please?
Vice Mayor Kerr,
Yes.
Commissioner Gabayie,
Yes.
Commissioner Taglerini,
Yes?
Commissioner McGeehan,
Yes.
Mayor Brooks.
Yes.
The motion carried 5-0.
Next is the consent agenda. I will read the items on the consent agenda. A is ITB number 25-14, Johns Pass dredging contract approval. B, interlocal agreement with Pinellas County for disaster debris and monitoring services. C, interlocal agreement with Pinellas County for designation of collection and removal responsibilities within geographic Pinellas County. D, street sweeping services, Sweeping Corp of America contract approval. And E, Madeira Beach City Manager brochure. If everyone is okay with the consent agenda, do we have a motion?
Mayor, do we need
Yes.
to pull out the street sweeping services to allow for Attorney Trask to, or to include that in the approval?
And we also need to pull Madeira Beach City Manager brochure to talk about the date.
Today, the date.
So if we could pull those two items and approve A, B, and C.
Okay, do we have a motion?
I move we pass a consent agenda for items A, B, and C on the agenda.
Do we have a second?
A second.
City Clerk, would you call the roll, please?
Commissioner Taglerini,
Yes.
Commissioner McGeehan,
Yes.
Vice Mayor Kerr,
Yes.
Commissioner Gabayie,
Yes.
Mayor Brooks.
Yes.
The motion carried 5-0.
Next on the agenda is the street sweeping services, Sweeping Corp of America contract approval. Do we have a motion?
So I'm just requesting that the motion be made to approve the contract with the language negotiated through the city attorney's office.
I'll make a motion to approve the street sweeping services with the contract language interpreted by the city attorney.
Do we have a second?
Second.
City Clerk, would you call the roll, please?
Vice Mayor Kerr,
Yes.
Commissioner Gabayie,
Yes.
Commissioner Taglerini,
Yes?
Commissioner McGeehan,
Yes.
Mayor Brooks.
Yes.
The motion carried 5-0.
Next on the agenda is the Madeira Beach City Manager brochure. We need to add in the date if someone would like to make a motion.
I move that we approve the brochure with the insertion of January 26, 2026 as the due date for resumes.
Do we have a second?
I'll second.
City Clerk, would you call the roll, please?
Commissioner Taglerini?
Yes.
Commissioner McGeehan? Vice Mayor Kerr?
Yes.
Commissioner Gavayi?
Yes.
Mayor Brooks?
Yes.
The motion carried 5-0.
Next on the agenda is public hearings. A, Resolution 2025-14, Affordable Housing Property Tax Exemption. City Attorney?
Thank you, Mayor. I'm going to read this resolution by title only. This is Resolution 2025-14, a resolution of the Board of Commissioners of the City of Madeira Beach, Florida, opting out of providing the 80 to 120% AMI missing middle property tax exemption to developments that would otherwise qualify pursuant to House Bill 7073 and providing for an effective date. That was the reading of Resolution 2025-14 by title only. This is very similar to the resolution that you adopted last year. We just changed the date on it. And so we're asking for your consideration of approval on this one.
Do we have any public comment? Commissioners?
Madam Mayor, I'd like to make a motion to approve, to adopt Resolution 2025-14.
Do we have a second?
Second?
City Clerk, would you call the roll, please?
Commissioner Gavayi?
Yes.
Commissioner Taglerini?
Yes.
Commissioner McGeehan?
Yes.
Vice Mayor Kerr?
Yes.
Mayor Brooks?
Yes.
The motion carried 5-0.
Next on the agenda is ordinance 2025-19, C3 zoning district setbacks, second reading and public hearing. City Attorney?
Thank you, Mayor. This is ordinance 2025-19, an ordinance of the City of Madeira Beach, Florida, amending Chapter 110 zoning, Article 5 districts, Division 7, C3 retail commercial, Section 110-321 setback requirements of the city's land development regulations to reduce the front and side setbacks, providing for conflict, providing for severability, providing for codification, and providing for an effective date. That was the second and final reading of ordinance 2025-19 by title only. It does require a public hearing. I'm not sure if Marcy wants to give any staffing on this. This is the second reading of this ordinance. You've already received staffing on it. Whatever your direction is.
So this was a privately initiated amendment to our zoning code that staff does support to reduce the front yard setback in the C3 retail commercial zoning district from 25 feet to 10 feet, and then to reduce the side yard setback for lots 120 feet or less. And we still would be maintaining the 10-foot minimum side setback required for corner lots or lots that have side yard street adjacent. And in the staff memo listed in various or comprehensive plan or special area planner, I guess, now adopted Madeira Beach master plan that support this this code change.
Do we have any public comment? Commissioners, do you have any questions or comments?
This aligns with our master plan. There's been no changes since our first vote. I move the approval of ordinance 2025-19 C3 zoning district setbacks.
Do we have a second?
Second.
City Clerk, would you call the roll, please?
Commissioner Taglerini?
Yes.
Commissioner Gavayi?
Yes.
Commissioner McGeehan?
Yes.
Vice Mayor Kerr?
Yes.
Mayor Brooks?
Yes.
The motion carried 5-0.
Next on the agenda is ordinance 2025-20, certified recovery residences, first reading and public hearing. City Attorney?
Thank you, Mayor. This is ordinance 2025-20, an ordinance of the City of Madeira Beach, Florida, amending Article 6 supplementary district regulations of Chapter 110 zoning of the land development regulations by creating Division 16, certified recovery residences, providing for definitions, providing for procedures for the review and approval of certified recovery residences, providing for requests for reasonable accommodations, providing for revocation of reasonable accommodations, providing for codification, severability, and an effective date. That was the reading of ordinance 2025-20. It's the first reading by title only. Remember that this is an ordinance that is basically required to be adopted because of the fact that there was a law enacted during the last legislative session, and the law specifically provides, and I'll just read this, by January 1st, 2026, the governing body of each county or municipality shall adopt an ordinance establishing procedures for the review and approval of certified recovery residences within its jurisdiction. The ordinance must include a process for requesting reasonable accommodations from any local land use regulation that serves to prohibit the establishment of a certified recovery residence. So it's required by statute. We've drafted the ordinance. I would bring to your attention there are two technical additions that we have added that are not in the statute, and they are on page 127 of your packet or page 5 of 7 of the ordinance. And that's paragraphs D4 and D5. D4 requires a survey of the property be provided to the city with the application, and D5 requires a scale drawing showing all the proposed site development on the property with the application as well. So it's here for a public hearing and approval.
One thing I would like to add, we brought this to the Planning Commission, and one thing they had requested clarification on is because they're varying levels of the recovery residences. We did confirm the permit application, if we do receive one, is specific to that level. And if a level was to change, then we would have to go through the permit process again. So what we're going to do is once we create, they reference a form in here that will have to be submitted to the Community Development Department. And within that form, we will reiterate that any level changes will require to revisit the permitting process.
Do we have any public comment? Commission, comments or questions?
Can you remind me again, how many levels are there in the recovery program?
There's 4.
There's 4?
I just have a question. Can this be restricted to I don't know what the zoning districts are, R1, that's more like weekly rentals or nightly rentals, areas that have short-term rentals already approved? Can it be restricted within, so that, and I may have this wrong, R3, that's 6 months, right?
So R1 is the long-term, you have to have long-term.
All right, I have it flipped.
Yeah. and
Okay.
R2 is minimum of 3, R2 is minimum 3.
So R3 would be the one that has a short-term rental.
Correct.
Because I wouldn't have a problem with this within areas that we already have short-term rentals. My issue is where that's not allowed, where you have a 6-month or 3-month rental. So I don't know if that can be written into the ordinance that we write. So we're allowing it, but we're not allowing it throughout the entire city.
I think that would be a legal question for Tom based on
So I don't really
statute.
know the answer to the question other than even if it was not allowed in particular areas, they would have the ability to ask for an accommodation. That's the whole purpose of the statute, is to allow these types of recovery residences to be placed in the city. The statute was adopted specifically because small cities or even larger cities have shunned these types of facilities, and the Florida's legislature and the governor believes it's very, very important. That's why they've codified it and required us to adopt it. So I wouldn't want us to get us into a position where we've made it so difficult to have one of these residences in the city that we're found to be in violation of the statute. So I would not recommend that you add any additional qualifications on these homes, because they're basically like any other group home that you have in the city. It's just for a different purpose. So,
But it also goes against the rental policy that was established decades ago.
I would foresee that the rental of the property would probably be for the longer term, but like Trask had described previously, you would just have residents coming and going. If you have a 3-bedroom house, then those 3 bedrooms would be occupied by whoever at whatever time. But I would foresee the rental aspect of that still would have to meet our code requirements. So they may rent it still for a year, but you wouldn't be able to control how they come and go, the people who live within the home, if that makes sense. That's kind of what I think we're up against here, is they may very well have a much longer lease on the property.
I mean, if our hands are tied and the state's saying we need to do it, or we're subject to not getting state funding or grants or whatever, then we would have to vote for it. But I'm just trying to find out if there's a way to have both.
Understood. And
That it's, you know, yeah, over 50% of the city, we allow it, but you have to, I don't know, that's just, I don't want to see neighborhoods broken up over this, that's all.
I'm not aware of any application that the city's received during my entire tenure at the city of Madeira Beach. So I'm not sure that this is such a big issue.
Okay.
But,
Just voicing concern, that's all.
oh, and I understand. I just don't know how that, you know, if it hasn't been a concern so far, us creating a process to allow for it, I don't think it would change anything other than if you're going to do it, this is the process that you need to go through versus willy-nilly coming to the city and saying, I'm going to build one of these things here, or I'm going to lease one of these things here. This creates a process for us to review it at least.
Any additional comments? Do we have a motion?
I'd like to make a motion, Mayor, to adopt ordinance 2025-20 with the additional requirements of D4 and D5.
Do we have a second?
Second?
City Clerk, would you call the roll, please?
Commissioner Gavalle,
Yes.
Commissioner Taglerini,
Yes.
Commissioner McGeehan,
Yes.
Vice Mayor Kerr,
Yes.
Mayor Brooks.
Yes.
The motion carried 5-0.
Next on the agenda is ABP 2025-06, Dockside Dave's Restaurant. City Attorney?
Yes, I just remind you, the next 3 items on your agenda are all quasi-judicial hearings, so there is a process that we need to follow pursuant to your code, and I'm going to lead you through that process. On the first application, which is ABP 2025-06, Dockside Dave's Restaurant, the property is located at 14701 through 14703 Gulf Boulevard. Summary of the application is that pursuant to Land Development Code, Article 6, Division 6, Alcoholic Beverages, the applicant for the APP 2025-06 is seeking a quota for COP alcoholic beverage license for the sale of beer, wine, and liquor for consumption on premises at Dockside Dave's Restaurant, located at 14701 Gulf Boulevard and 14703 Gulf Boulevard here in Madeira Beach. This application is being made pursuant to Section 110-534, change of alcoholic beverage zoning, because the applicants request a change from a special food service establishment for COP alcoholic beverage license to a quota for COP alcoholic beverage license. The standards to be applied, and I'm only going to read this once, but we're going to use the same standards for all 3 of these cases. That'll shorten our little time to go through this, if you don't mind. So the standards are under Section 110-532. When considering the alcoholic beverage application, the Board of Commissioners shall consider the following factors. Number 1, the extent to which the location and the extent to which the proposed alcoholic beverage request will adversely affect the character of the existing neighborhood. Number 2, the extent to which traffic generated as a result of the location of the proposed alcoholic beverage request will create congestion or present a safety hazard. Number 3, whether or not the proposed use is compatible with the particular location for which it is proposed. Number 4, whether or not the proposed use will adversely affect the public safety. And the last factor is that no application for review under this section shall be considered until the applicant has paid in full any outstanding charges, fees, interest, fines, or penalties owed by the applicant to the city under any section of the code. The burden of proof as required by Section 2-10 of your code reads as follows. The applicant shall have the burden of proof at the hearing to show by a greater weight of the evidence that the application is consistent with the city's comprehensive plan and complies with all procedural requirements of law. Conditions may be suggested by the applicant, the city, or any party, or may be imposed by the board, which are intended to assure consistency and compliance. The parties in this case, since there have been no notices of intent to become an effective party filed in this case. There's only two parties, the city and Dockside Dave's Real Estate LLC. The order of the presentation, since there are only two parties, the city is going to present first, and then Dockside Dave's will have an opportunity to do that. So I need now read to you the quasi-judicial rules and procedures. This is a quasi-judicial proceeding where the Board of Commissioners acts in a quasi-judicial rather than a legislative capacity. At this hearing, it is not the board's function to make law, but rather to apply law that has already been established. In this hearing, the board is required by law to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The board may only consider evidence at this hearing that the law considers competent, substantial, and relevant to the issues. If that competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has met the criteria established in the Code of Ordinances, then the board is required by law to find in favor of the applicant. By the same token, if the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinances, then the board is required by law to find against the applicant. So now I need to ask each and every one of you whether or not you need to disclose any ex parte communications that you've had with the applicant or anyone else. Does anyone need to disclose any of those communications? No.
No.
I'm seeing all the shaking of no. Any conflicts of interest that any of the Board of Commissioners need to disclose? I'm seeing no. Okay, at this point, I need to swear in all witnesses. So anyone that's going to speak on this agenda item, if you could stand up, raise your right hand. I'm going to swear you're under oath. Is there? Okay, anyone here for Dockside Dave's? Okay. You swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? Okay, thank you very much. So with the witnesses sworn in, the city can go ahead and proceed. Andrew, are you going to be making this presentation? Yes, sir. Okay, we need to get that mic on.
It should be on now.
Yeah,
Okay.
okay.
When considering the alcoholic beverage license application, the Board of Commissioners shall consider the following factors. The first one is the extent to which the location and extent to which the proposed alcoholic beverage request will adversely affect the character of the existing neighborhood. Dockside Days is proposing to change from a special food service establishment 4COP alcoholic beverage license to a quota 4COP alcoholic beverage license. The quota 4COP alcoholic beverage license does not require a percentage of gross food and beverage revenue to come from non-alcoholic items, and it does not require a minimum number of physical seats. The special food service establishment 4COP license requires a minimum number of 120 physical seats and 51% of the gross food and beverage revenue to come from non-alcoholic items. Dockside Dave's still plans to operate as a restaurant, but would not be required to meet the seating and food sale requirements of the previous license. This proposed change will not have a negative impact on the existing neighborhood character since the applicant proposes to continue to operate as a restaurant. The existing neighborhood is mostly commercial or multifamily uses, and the existing restaurant already has a special food service establishment 4COP alcoholic beverage license to serve beer, wine, and liquor on the premises. Additionally, the Reef Bar and Grill located adjacent to this property already serves liquor. The next one is the extent to which traffic generated as a result of the location of the proposed alcoholic beverage request will create congestion or present a safety hazard. As proposed, the quota for COP alcoholic beverage license use does not present a safety hazard or lead to additional congestion. Dockside Dave's does meet the parking requirements of the city's land development regulations when the 5 off-site shared parking spaces are included in their total parking count. The off-site shared parking spaces will be for employees only, and all proposed parking on site will accommodate customers based on the number of seats indicated in the approved site plan provided. If the property of the off-site shared parking is redeveloped, Dockside Days would be out of compliance with the city's parking regulations unless they found additional parking. Attached to the memo is a copy of the off-site shared parking agreement. The one attached was a draft one. Attorney Trask and there, they worked on a revised shared parking agreement based on So there are some differences. And if the alcohol license is approved, they would need to record it into the Pinellas County records. Tom, do you have anything to say about the shared parking agreement?
I'll let you finish your,
Okay, no problem.
your presentation, and then I'll address those issues.
Okay, thank you. And then under Figure 1 is a screenshot of Dockside Days parking requirements from their approved site plan. The next one is whether or not the proposed use is compatible with the particular location for which it is proposed. The proposed change in alcohol beverage license use is compatible with this location since Dockside Days would continue to be a restaurant. Nearby businesses like the Reef Bar and Grill already serve liquor. Dockside Days would continue to focus on food, and the alcoholic beverages would complement the food. Whether or not the proposed use would adversely affect public safety should not be adversely affected by Dockside Days restaurant changing from a special food service establishment 4 COP alcoholic beverage license to a quota 4 COP alcoholic beverage license. The restaurant is more than 500 feet away from any established church, synagogue, temple, or place of religious worship, public or private school operated for the instruction of minors, or youth recreation community center. The 500-foot requirement is a minimum distance required for bars and clubs located in the C3 zone district and does not need to be met for restaurants. Dockside Days is classified as a restaurant. The next one is no application for review under this section shall be considered until the applicant has paid in full any outstanding charges, fees, interest, fines, or penalties owed by the applicant to the city under any section of the code. The applicant has no outstanding fines or penalties owed to the city under any section of the code. And then under staff recommendations, staff recommends the approval of ABP 2025-06 with the following conditions. The applicant must maintain a minimum of 5 parking spaces off-site. If there's a change to the existing contract, Dockside Days will need to submit a revised contract and site plan showing where the new parking spaces would be located. Per the attached site plan sheet SP 1.0, the area labeled no open entertainment space permitted cannot be utilized for additional seating, standing space, or open entertainment space, with the exception of the applicant applying for a special events permit as defined in Article 2 Special Events. Attached is their local application. There's a previous draft of their parking agreement now, and the public notice mailing and posting. And attached to their local application is the approved site plan. If you have any additional questions, I'm happy to answer them. Or
Before we get to questions, you want your staff memorandum and attachments to be received into evidence, correct?
yes, sir.
Okay. All right. So any questions from the commission about the presentation that Mr. Morris gave?
I have one question. How come we don't have scale drawing as a part of this package? It's all seemed to be blown up and mixed copies and just doesn't, it's not, doesn't look like a full site plan.
So because it's in this agenda packet, it shrunk down the size. So if we pulled this up in Bluebeam, it would be to a full scale site plan. It shrunk it down to fit in the agenda packet. And I think, like actually looking on the PDF, it's pretty large, but the printer they shrunk it.
So staff's is approving the site plan, you know that there's plenty of handicap spaces, accessibility to none of that I would be interested in is shown here. So I'm just gonna depend on you to have looked at it and have been okay with it.
Correct. So as separately with this, they've obviously been doing the remodeling work, and during that review process, they've met the parking requirements on site, including handicap, and then of course they have the additional 5 spots off site, which will be utilized by staff. But yes, during our original site plan review for their permitted work, we have reviewed all of that.
Okay. Thank you.
Any other questions from the commission? Okay, there being no other questions. Sir, do you have any questions of Mr. Morris about his testimony? Okay, no. The city have any other witnesses that you wanted to call? Andrew? No?
I'm good.
Okay. So now it would be appropriate for the applicant to step forward and make any presentation that he would like to make. Sir, if you could come forward, state your name, your relationship to the property and the application, and any other information you want the commission to know.
Brandon Nazario, Dockside Days. I'm the owner. Commissioner, it's awesome to see you again, and Mayor, it's good to see you. Marcy and Andrew, thank you for helping me with everything so far. They've been awesome. They've been really good. I don't think I have any questions, but if you have any questions for me, I'd be gladly.
Any questions for Mr. Nazario?
I do. Can I ask, so I want to ask questions about the recommendations staff made to us in approving, okay.
Absolutely.
So there are two recommendations that staff made. One was that you maintain the 5 parking spaces off-site, and the second is the no open entertainment space permitted. So in reviewing the drawings, it's very specific where you can't have open entertainment. So I'm curious, are you going to have entertainment, live entertainment? And if I'm reading it correctly, the only place you can do that is in the new small building. There's a very small square area that says entertainment.
Yes.
So there won't be any entertainment outside or, okay. The reason I bring that up, Commissioner Taglerini, is when we've discussed the noise ordinance and talked about if we're approving things that are outside of the noise ordinance, how are we maintaining that? And this is a great example for you. So, okay, I have a question for you, but I should wait till I'm done with him.
So if you're done with your questions,
I am.
Any of the commissioners have questions of the applicant? I'm seeing no, okay. So I'd be happy to answer any questions you have.
Okay, so this is my question. So in the past, when the commission has approved things, there would be conditions placed on it, and then those conditions go away after a period of time. So that I understand, it's very defined that they can't have open entertainment outside. Do we need to memorialize that in some other fashion than it just being part of the approval so that it's enforceable for years to come? Or, I mean, is that something that should be a concern or a conversation?
Well, first of all, the city should be, at the end of each one of these hearings, the city should be issuing a letter saying your application has been approved or denied.
Right.
Your application has been approved with the following conditions, and that is the documentation, and the conditions don't go away.
Okay.
Okay?
Okay,
So
that's-
if in this particular case, they fail to have the 5 off-site parking spaces, I would think that city staff would immediately bring it back to you to have you revoke that alcoholic beverage permit, because that was a condition of the permit. The contract, there was a question by Mr. Morris about that. I just want to address the parking agreement right now. Your code is very specific as to what needs to be in that parking agreement. So I worked with the property owner and the parking lot leasing agent and their attorneys to develop a parking agreement. They have met all the terms that I requested in the agreement. Specifically, what I was concerned about is what happens if the lease agreement goes away. Well, there's a legal obligation on Mr. Nazario and his company to immediately notify the city that either the underlying agreement or his agreement has been terminated. Once that notice is brought to you and he doesn't have the ability to get the 5 spaces again somewhere else, then obviously you would want to address the alcoholic beverage permit. But the agreement will be recorded in the public records, so it will become like a deed being recorded, and it is an obligation of the property owner and the parking agreement company, or the parking company, and Dockside Dave's. So I think that we've covered all the issues. There's no way we can draft such an agreement that makes them never make those parking spaces go away. But he's done his best that he can do to get these spaces under this agreement. And I believe the agreement meets the requirements of the code. And so this is the agreement that would be attached to that letter that I was just mentioning to you as being a condition.
Okay.
So.
And because I brought up the entertainment thing, I did want to say that my understanding is they can get special event permits to have entertainment outside.
That's what the condition is, yes.
Yes. I just want to be sure I said that, because.
Okay. Awesome.
Okay, if there's no other testimony from either the city or the applicant, I would want to open it up to the public for anyone to speak, so have a seat. Thank you. Anyone from the public want to step forward? Mr. Dillon, did you want something to say? Okay.
Chuck Dillon, Lillian Drive. It's great to see the city finally coming back. This is one of the many steps, this and the other two things about bringing the city back to life and getting food back in our city so we don't have to go other places. Thank you.
Thank you.
Any other public comment? All right, there's no other public comment. It comes back to the commission for consideration of the application. Should be a motion to approve, and you could vote it up or down. The motion to approve should include the conditions that are listed by staff recommendation.
I'll make a motion to approve ABP 2025-06 Dockside Dave's Restaurant with including the special circumstances with the parking lot.
You just need to move staff recommendation of the two conditions. We need
With
to
staff recommendations of the two conditions.
Okay.
Second.
City Clerk, would you call the roll?
Commissioner McGinn,
Yes.
Commissioner Gabai,
Yes.
Commissioner Taglerini,
Yes.
Vice Mayor Kerr,
Yes.
Mayor Brooks.
Yes.
The motion carried 5-0.
All right, thank you.
I think I can say for everybody, we're super excited for them to open, and I speak on behalf of myself, the commission, and many, many, many visitors that come to our city. It's probably one of the number one questions I see on social media is when is Dockside Dave's going to open? So thank you, staff, because I know you all worked very hard to help them be in the position they are to open, so we're super excited for that.
And Brandon's been a consummate professional throughout this. He's been thrown a lot of stuff that he's had to learn, but he's been very receptive. And once he kind of understood where we were trying to go with it, he was really receptive to it. And you couldn't have a better commission. McGeehan had reached out to me a couple times about it, so just making sure you were on track. So we're excited about it as too, and agree it's a monumental opening to say that the city is recovering and getting back on our feet.
I 100% agree. Next on the agenda is ABP 2025-07, John's Pass Convenience Store and Rentals. City Attorney?
Thank you, Mayor. Commissioners, the applicant in this case is Corey Jennings and Coastal Rise LLC. The address of the property is 13045 Gulf Boulevard. There are no notices of intent by persons seeking to be an affected party. A summary of the application is that pursuant to Land Development Code Article 6, Division 6, alcoholic beverages, the applicant for APP 2025-07 is requesting authorization from the Board of Commissioners for the approval of a package sales to APS, alcoholic beverage license for the sale of beer and wine package sales for off-premises consumption at John's Pass Convenience Store and Rentals at 13045 Gulf Boulevard here in Madeira Beach. I've already gone over the standards. We're not going to repeat them. They're the same as the last case. The burden of proof is the same as the last case. Since there are no affected parties, the only parties are the city, Mr. Jennings and Coastal Rise LLC. The city will therefore present first. I've already read the quasi-judicial procedures. They're the same for this case. Question to each one of you, any ex parte communications that you need to be disclosed?
No.
No. Any conflicts of interest that need to be disclosed? No. All right, I need to swear in all witnesses. City staff's already been sworn in, so if there's anybody in the public or the applicant here for this application, you can stand up, raise your right hand, and be sworn under oath. Are you here for this application? No? Okay, I guess the applicant's not here. Staff's already been sworn, so Andrew, are you handling this one? Okay, you can go ahead and proceed then.
Okay, thank you. The extent to which the location and the extent to which the proposed alcoholic beverage request will adversely affect the character of the existing neighborhood. The traditional village character district of the Johns Pass Village Activity Center is focused on commercial uses to cater to both residents and visitors. A convenience store selling beer and wine would be a compatible use for the location. The proposed alcohol use would not adversely affect the character of the existing neighborhood. There are nearby businesses that have various types of alcoholic beverage licenses. The next set of criteria is the extent to which traffic generated as a result of the location of the proposed alcoholic beverage request will create congestion or present a safety hazard. The traditional village character district of the Johns Pass Village Activity Center is a walkable commercial area where customers can walk between their shopping and eating destinations. This establishment is in the Johns Pass Village parking area listed in section 110-954 special parking areas. The proposed alcoholic beverage license use would not create additional congestion or present a safety hazard. Johns Pass convenience store was previously located along Fisherman's Alley. Their previous store was damaged during Hurricane Helene. At the previous location of the Johns Pass convenience store, they did have a package sales to APS alcoholic beverage license. The proposed alcoholic beverage license would be the same level of intensity and not generate additional traffic more than their previous location. The applicant clarified that their lease includes 2 parking spaces. One space would be used for employee parking, the other space would be used for customer parking. Since the establishment is located in the special parking area, the proposed parking will be sufficient. Whether or not the proposed use is compatible with the particular location for which it is proposed. A convenience store would be a compatible use in this location since it is a commercial use and would be near other commercial uses. Many of the nearby tenants have various types of alcohol beverage licenses. The structure that the establishment is located in has previously had other commercial tenants. The proposed use is compatible with the location. The next is whether or not the proposed use will adversely affect the public safety. Public safety should not be adversely affected by the Johns Pass convenience store and rental selling beer and wine, package sales for off-premises consumption. The convenience store is more than 500 feet away from any established church, synagogue, temple, or place of religious worship, public or private school operated for the instruction of minors, or youth recreation community center. There are businesses nearby that already sell alcoholic beverages. The applicant has no outstanding fines or penalties owed to the city under any section of the code, and under recommendations, city staff recommends the approval of ABP 2025-07, Johns Pass Convenience Store and Rentals. Attached is the local application and the mailing and posting notices that were done 15 days out. That's the conclusion of my presentation.
You're asking that the memorandum, your staff report, and the application and all the attachments be received into evidence?
Yes, sir.
Okay. Any questions of Mr. Morris from the commission? Seeing none. Okay. The applicant's not here, so it kind of shortens what we have to do. Does anybody from the public want to address this application? Not seeing one there, so it's back before the commission for your consideration of the application as presented without the applicant.
I don't have any.
I have a question. Are the parking spaces existing? Are all of them already striped? Because dimensionally, none of them works. When you look at the.
I mean, I think they've been there for a very long time. It's one of those kind of older, legally non-conforming structures that have kind of oddly shaped parking spots. Obviously, if they ever redeveloped the site, they would have to, it doesn't relate to this alcohol permit, like it'd have to be brought in compliance, but as it I mean, it's just existing stuff. So.
Just from public safety, I would be concerned about cars that cannot really back out. There's not enough space between the parking spaces and the drive aisle to, at a 90-degree angle, to back out. It appears minimal. But if it is what it is, it's been like that, no striping, restriping, then I guess we have to live with the situation.
Yeah, this came with, this was not part of any other permit or site plan review or anything like that. It's just strictly just adding the sale of alcohol. So if for us, it doesn't trigger, for this request, it wouldn't trigger us to make them become like fully compliant unless they wanted to, if they started to stripe or touch the parking lot at that point in time, then it would trigger the full compliance. But at this point in time, we have nothing before us that they'll be doing any site work like that.
So what they're requesting doesn't require additional parking?
As the convenience store of the,
It doesn't require additional parking, and it's in a special parking area, and the store's like 300 square feet. It's very, very little store, so, but the two spaces that the applicant said in the email are sufficient.
Thank you.
Okay, it's up to the commission to decide whether you want to approve the application.
I recommend the approval of ABP 2025-07 John's Bass Convenience Store and Rentals.
I'll second.
City Clerk, would you call the roll, please?
Commissioner Taglerini,
Yes.
Vice Mayor Kerr,
Yes.
Commissioner McGeehan,
Yes.
Commissioner Gavayi.
Yes.
Mayor Brooks.
Yes.
The motion carried 5-0.
Next on the agenda is ABP 2025-08 Broken Board Bar and Grill. City Attorney?
So I'm not going to even try to say this name. We'll have the applicant step forward and say his name, but DeGetto, maybe first name. But this is for the property located at 15015 Madeira Way, Suite 100. A summary of the application is pursuant to the Land Development Code, Article 6, Division 6, alcoholic beverages, the applicant, APP 2025-08, is requesting authorization from the Board of Commissioners for the approval of a special food service establishment for COP alcoholic beverage license with stated intent to sell beer, wine, and liquor for the consumption on premises at Broken Board Bar and Grill located at 15015 Madeira Way, Suite 100 here in Madeira Beach. The standards to be applied are the ones that I mentioned in the first two cases. They're still the same. The burden of proof is the same. There are no affected parties that have filed notices of intent, so the only parties are the applicant and the city. The city should present first. I've already read the quasi-judicial procedures. They are the same for this case as the last two. I need to ask each and every commissioner any ex parte communications that you need to disclose?
No.
No. Any conflicts of interest that need to be disclosed?
No.
No. All right, I need to swear in any witnesses other than city staff. Sir, were you already sworn in earlier, sir?
Yes.
Okay. So now is for, well, first of all, can you tell us how to say the name?
Cheto, DJETO, Lujurai, LJULJ, DJURAJ.
All right. So that's why I didn't pronounce it?
When I was born, they had J's on sale, so I bought a couple more.
Oh, you've got a lot of them there. All right, we're going to have you hang on right there, but the city staff needs to go ahead and make its presentation, and we'll ask you to participate.
Okay, so when considering the alcoholic beverage license application, the Board of Commissioners shall consider the following factors: the extent to which the location and the extent to which the proposed alcoholic beverage request will adversely affect the character of the existing neighborhood. The property has a future land use designation of planned redevelopment mixed use and is surrounded by other properties with this future land use designation. The planned redevelopment mixed use future land use designation is given the properties located within the Madeira Beach Town Center Special Area Plan. This property is in the commercial core district of the Madeira Beach Town Center Special Area Plan. This district supports commercial uses and commercial mixed uses that are walkable. There are other nearby businesses that sell alcoholic beverages. A restaurant that serves beer and wine liquor would be an acceptable use for the property and would not adversely affect the character of the existing neighborhood. Property is located within the Madeira Beach, the extent to which the traffic generated as a result of the location of the proposed alcoholic beverage request will create congestion or present a safety hazard. Properties located within the Madeira Beach Town Center Special Area Plan have a reduced parking requirement that is 50% less than other areas of Madeira Beach. The restaurant is attached to a hotel structure that has a parking garage. The property has sufficient parking for both the hotel and restaurant uses. The traffic generated from this proposed alcoholic beverage request would not create congestion or present a safety hazard. Whether or not the proposed use is compatible with the particular location for which it is proposed. Don the Beachcomber was previously using this location and had the same type of alcoholic beverage license. The proposed alcoholic beverage license use would be compatible with the existing structure and with the zoning and future land use designation of the property. The property is not located within 500 feet of a church, synagogue, temple, or place of religious worship, public or private school operated or the instruction of minors or youth recreation community center. Whether or not the proposed use will adversely affect public safety, the requested license is not anticipated to adversely affect public safety for the special food service establishment for COP alcoholic beverage license. The state of Florida requires at least 51% of gross food and beverage sale revenue to come from the sale of food and non-alcoholic beverages. The previous tenant, Don the Beachcomber, had a special food service establishment for COP license. The proposed alcohol beverage license request would not adversely affect public safety more than the previously approved alcoholic beverage license use at this location. The applicant does not owe any outstanding charges, fees, interest, fines, or penalties to the city. And under recommendations, city staff recommends approval of ABP 2025-08 Broken Board Bar and Grill. Attached is the local application. They're proposing to keep the same amount of seating as the previous tenant did. And then also attached is the public mailing notice postings.
Okay, and you're asking that your memorandum, your staff report, and all the attachments be received into evidence?
Yes, sir.
Okay. Any questions from the commissioners, the mayor, about Mr. Moore's testimony? Not seeing any. Okay, sir, do you have any questions, we call cross-examination of Mr. Morris about any of the testimony that he's given today? Any questions of Mr. Morris?
No, sir.
Okay. City have any other witnesses? No? Okay, so sir, now is your opportunity to make any presentation that you want to the commission. Tell them anything you need.
Well, the place is not changing anything, pretty much the way it was.
You can direct your comments to the commission.
Okay, the place is not changing anything from what it was before. All we're doing is maybe better food and pretty much doing whatever they were doing before, like a bar, restaurant. We will use the patio. As far as entertainment, we will have. Pretty much with the city's guidelines, we're not going to go till 6 o'clock in the morning or anything like that, but we will follow the city rules till the time that the city allows it. We not want some kind of place. I had a place in Indian Shores. We never had issues. I have still one in Reddington Shores. Never an issue, so I don't think you guys are gonna have an issue with me. I'm not a troublemaker. But any questions you guys have for me, I'm here to address it to the best of my knowledge.
Any questions from the commission?
I just want to say in the prior restaurant that was there were noise issues from the outlet. I mean, it was a wonderful, nice setup and their outdoor patio, but there's condos right next to it. And there were times you could drive through the intersection and hear music. I wonder if you're sensitive to that situation and if you have any plans to, I mean, they were more or less in our ordinances, but they pushed it to the limit, it seemed like. Do you have any thoughts on that?
There will be no issues with that. In the outside, mostly it's going to be piano, type slow.
It's volume.
The volume.
I guess not genre.
It's not going to be any issues.
Right. Thanks. I look forward to visiting your restaurant.
Thank you. We'd be glad to have you.
If there are no other questions from the commission, I'm going to open it up to the public. Is there anyone in the public in the audience today that wants to go ahead and, okay, Mr. Dillon, sir, thank you. Mr. Dillon, you've already been sworn under oath. You don't need to be sworn again, okay?
One I'd have to say, if it is the same business that's up north, they have delicious food, and I'm looking forward to them also. And hopefully you can keep 5,000 square feet going. There hasn't been many restaurants there that can keep the business. So, but good luck to you. And if they are related, it's delicious food. Looking forward to it.
Okay. Anyone else from the public want to address the commission? Okay, so now it's back to the commission for consideration of this application.
I'm in favor of it.
Yeah, I would tend to follow the city staff recommendation.
Yep. Do we have a motion?
I move the approval of ABP 2025-08, Broken Board Bar and Grill.
Do we
I'll
have a
second.
second? City Clerk, would you call the roll, please?
Commissioner Taglerini,
Yes?
Commissioner McGinn,
Yes.
Commissioner Gavayi,
Yes.
Vice Mayor Kerr,
Yes.
Mayor Brooks.
Yes.
The motion carried 5-0.
Moving on, we have no unfinished business or contracts agreements. There is no new business, so we move to the agenda setting for January 28th, 2026, BOC regular workshop at 2. I have 3 things that were in our earlier discussion to bring back, which would be an update for the parking garage, the jetty, and then the piece of property that Vice Mayor Kerr mentioned, wanting us all to review. If we could briefly touch on those 3 items.
Mayor, there's one additional one. The city has received a request for a fine reduction for a code enforcement lien on the property located at 703 Sunset Cove. I believe that you've all received the memorandum with a little bit of backup on it, so I'd like to add that to the agenda as well on January 28, if that is acceptable. And remember, the process is to review it at the workshop and then act upon it at a regular meeting. Okay.
Anything additional?
Thank you.
Next on the agenda is reports and correspondence. Board of Commissioners reports and correspondence. Does anyone have?
Mayor, I
any?
do have a correspondence.
Yes, please.
I'm uncomfortable with this, so forgive me if I read a lot. Mayor and fellow commissioners, I'm bringing this to you under the communications because, sorry, I hear. I'm bringing this to you under communications because I received an email from Mr. Trask regarding an ongoing complaint against my campaign finances of 2 years ago. The email reads in part, the email below discusses your entitlement to be reimbursed for legal fees for an ethics complaint. The charter does not mention reimbursement for legal fees for an election matter. I apologize for mixing these 2 topics and leading you to believe your election complaint fees are reimbursable by the city. They are not reimbursable. Let me know if you have any questions. So before I get to the gist of this, I want to provide some background to help you understand the complaint to which this email is referring. On April 7th, 2023, a year after I was elected, roughly, I received notification that a complaint had been filed against me stating that I was in violation of Florida's election laws by John Hendricks, former mayor of Madeira Beach. The complaint included 24 alleged violations. 22 of the violations were because no occupation was listed for the contributor. However, in each of the 22 cases, the contribution was $100 or less. And according to Form DS-DE 13, instructions under Item 8 states occupation of contributions over $100 only. Each of these donations was $100 or less. So those 22 items were invalid. One item stated that there was no address listed for a contributor of $20. This was a mistake on my part. However, the report was amended on January 16, 2022, more than a year before the complaint was made. So now 23 of the 24 items have been corrected. The 24th item was that my final summary did not reconcile, and at one time that was true. However, the final report was submitted before the deadline. I turned it in on time. However, it happened to be shortly before I left for a 1-month planned vacation out of the country. It was my intention to correct the difference upon my return to the U.S., but frankly, my first year on this board was a whirlwind, and to be honest, life got in the way and I put it off for several months. Several months later, upon reviewing my notes, I was reminded that I needed to amend my report so that it was reconciled. I found my error and submitted a reconciled report before I received the complaint. Full disclosure, the reason for my error was my misunderstanding of the way GoFundMe works. I used GoFundMe to raise the majority of my money, my campaign funds. I'd never used this source for anything in the past, and to summarize, I subtracted the GoFundMe fees twice. Once I discovered the error, my report balanced to the penny. The short story of this situation is that every alleged violation on the complaint was invalid by the time I received the complaint, and many of the items were invalid before any amendments were necessary. They were just false accusations. I'm not sure why John Hendricks chose to make this complaint, but I will say that my time on this board with him was most unpleasant. On the day of my swearing in, with my friends and family present to help me celebrate, which should have been a proud day for me, John Hendricks welcomed me to the board by saying, "I can already see the wasteful spending." And that comment set the tone for my first year on the board. I received the complaint about a year after I had started serving on the board. I emailed Attorney Trask for his advice on my next step should be, and I asked if he could advise me. He informed me that he could not represent me, which made sense, but he gave me the contact information of a lawyer he recommended. I sent Mr. Trask a detailed account of the nature of the complaint as well as the complaint itself, and asked him if the city would be able to cover my legal fees. Mr. Trask responded, "I have attached Section 5.3 of the Charter. It prohibits me from representing an elected official in a Florida Commission on Ethics proceedings. I would recommend that you retain," et cetera. He made a recommendation, and I said, later, I asked him, will the city cover my fees? He said, "The city charter provides that you are entitled to have your attorney's fees paid by the city. Please consult with the city manager on how he will be handling that." Based on that response, I contacted Mr. Gomez and asked what I needed, and he said to get something in writing from the lawyer regarding his fees. Contacted the lawyer recommended by Mr. Trask, and he emailed me an outline of what his services would cost. I forwarded that to Mr. Gomez, and his response was, "Please have him send the invoices to," and he gave the city address attention to himself. This all happened April of 2023, 2 years ago, roughly. I've heard nothing from the city during that time regarding fees, and all I've heard from my lawyer is that these things take time. On December 1st of this year, I received the email from Mr. Trask stating in part, "The charter does not mention reimbursement for legal fees for an election complaint." I apologize for, this is what I read at the beginning. I apologize for mixing these two topics, leading you to believe your election campaign fees are reimbursable by the city. They are not reimbursable. The key words there are election complaint versus ethics complaint. I submitted the actual complaint, which says elections, and when Mr. Trask said ethics, I didn't question it. I thought maybe that's what an ethics, he's the legal expert, and I believe that an honest mistake was made. So at this point, I'm asking, in short, being asked to reimburse the city for legal fees, which apparently have been accruing for the last 2 years in the amount of roughly $600. Had I known that I would be responsible for these fees 2 years ago when this complaint was filed, I probably would not have retained a lawyer because, as I've said, the complaint was filed using false accusations, which I felt any reasonable elections board would see and close the case. What I'm bringing to the board today is that I'd ask that the board allow the city manager to authorize payment of my legal fees at least up to this point, as I was led to believe would be my right and was promised to be by the previous city manager. I will take responsibility from this point on for any fees that I might incur. Thank you for your consideration.
Can I just jump in? The commissioner is absolutely correct on the background. I think I've got a solution for this. I'll just give a credit to the city for the value of the attorney's fees so that there doesn't have to be an issue with the commission considering Commissioner Tagliarini's request. So whatever the value is of that invoice, which I think is in the $600 range, I'll just give the city a credit for that since I think it's already been paid. And then it's a non-issue at this point. So if that's an acceptable solution, because I really don't think that it's appropriate for the commission to authorize the payment of the attorney's fees, because I fail to see that there is a public purpose for that, and I don't want the city to be placed into a position or Commissioner Tagliarini to have that issue come up in a later complaint. So the city's already paid it. I'll give a credit to the city for that dollar amount, and I think that that addresses the issue, if that's acceptable to Commissioner Tagliarini and the commission.
$630 total.
So I'll give you a credit on your next bill for $630. Is that acceptable?
Yes, sir,
Commissioner?
thank you
You're welcome.
very much.
Yeah.
Do we have any public comment? So this is, we don't need to vote on this then
You don't need to
in
do
a future
anything.
meeting, do we?
No.
Okay. Commissioners, do you have any comments? I don't have any comments. Thank you. Next is the Board of Commissioners 2026 BOC meeting schedule. Did everyone review it and have any need for changes? Good. Then next on the agenda is the Board of Commissioners 2025 BOC Annual Meetings Report.
This was just for information purposes.
Thank you, Clara. I look forward to this. I like it. It puts everything we've done together.
And also, I'm gonna start adding each month, the Board of Commissioners budget and what your balance is each month and your expenditures. And I think that should go in your report.
Thank you, Clara.
Do we have any public comment? Next on the agenda is City Clerk.
Yes. The qualifying period for the March 10th, 2026 municipal election will end on this Friday, March the 12th at noon. There's 3 candidates that have qualified so far, and they have come in. And one was David Tagliarini. He qualified for Commissioner District 1. So Commissioner District 1 and 2 are up for election for March. And then incumbent Ray Kerr, he qualified for Commissioner District 2, and Chuck Dillon came in and qualified for Commissioner District 2. So if somebody comes in tomorrow, they'll still have time to qualify, but they have to have it done by noon on Friday, and that's it. That's all I have to say. And I look forward to the election. I'll get Trask the draft ordinance coming up for the procedures and who's on the ballot, and take it from there.
Do we have any public comment? Commissioners, any comments?
I would just like to say, before we adjourn, Merry Christmas to everyone out there that's watching, all of our Madeira Beach residents, and happy holidays, and we'll see you at the boat parade on Sunday.
Saturday.
Saturday, that's what I meant.
Next on the agenda is City Attorney.
I don't really have anything. I just wish everybody a Merry Christmas, Happy New Year. We'll see you in January.
Next on the agenda is City Manager.
I just wanted to give a quick update on a couple projects. The Johns Pass dredging, set to begin in January, still contingent upon when Pinellas County finishes their dredging of the channel. And then the Snack Shack sand removal, that will begin on December 22nd and go through December 27th with, of course, Christmas being an off day for the business or the contractor. But other than that, that's it from City Manager's office.
Do we have any additional comments, questions? We did not have any public comments at the beginning of the meeting, so it is 7:24. We are adjourned.
Thank you.